Thing working? Hi, Jody. I'm figuring out some new software, so bear with me. Yeah. Have to amuse yourself for a little bit here. Let's try that. There's a delay. Do you have sound? Can you hear me? I don't know if my audio is hooked up. Kind of isn't doing what I want it to do. So 5 by 5. Well, that's a good start. Let's see. Because I want you to be able to see my screen. Display capture. Okay. I mean, something's happening, so we're trying to build this airplane in midair here. This stream will end shortly unless you restart it in your streaming software. YouTube is not receiving enough video to maintain smooth streaming. All right. Hi, Sylvia. We're trying to figure out stuff here, so this is going to take a few minutes. You may just have to start over and do this from my telephone. Why is this locked? Video capture device. Let's see what happened there. Yeah, we might just have to bail on this one. And there's a slight delay in what I'm doing versus what I'm seeing. So give me another minute to just see what happens here. Talk amongst yourselves. I was kind of just trying to get this set up to do this. So this was kind of experimental. Okay, well, like, how do you do that? It's not exactly intuitive how to just make this work. Settings, video. Oh, here we go. Let's go 1,000. Stream is doing this to general. Come on, clicky. Okay. There's some kind of, let's see. Okay. That's helpful. Okay, here's what I need to do. This is what I need to do. Okay, so you're seeing the same thing I am. This is what I need to do. Okay, so you're seeing the same thing I am. Okay, I had done a video like this before, and camera is hooked up. Everything's happy, and yet it's not happy. Well, I guess you guys won't see me. You'll just be seeing my screens. Still don't get why this isn't working. Here we go. February. Oh man. Let's see. Yeah, I'm quite possibly just not ready to stream in this manner. Let's go here. Ah, here it is. Here we go. I'll just bring up the material we need to discuss. And if I can't figure out midstream here how to get what I need, or to get on screen on camera, I don't know why my camera is not picking up me if I switch back and forth. It's probably a simple fix. There's a better way to find this. Oh, that's what I'm on. This is how I found it before. Here we go. That's what I'm looking for. Okay, progress. This is nothing. Let's go do this. We're almost there, folks. Let's pull up one more tab, and I think I can do it instead of beside you. Ah, Bow is live. Ah, stream's over. I'm gonna go hang out with Val, clash with Val. What are we looking for? Oh, live. Well, as long as you can hear me and kind of see what I'm doing here. Where is it? Ah, here it is.
That's right, and we take accountability.
Let's pause this. Copy this. And we're here. Boop. YouTube is not receiving enough video. What? Are we still live? Anybody? Is anybody still here? Who's still here? Anybody? Nobody? I can't. Oh, here we go. I do this. Yes, I'm the only one here. Okay, while I'm waiting for people to come back. Oh, okay, so it is showing stuff. Where are we? This is the one I want to show. So as people trickle on back, I'm just going to play around with this so I can get my camera going. For some reason, why is this not displaying? Ooh, bad. Audio, video capture device. Rio 100. That's the one. Resolution. Okay, well, whoever's in here, we'll get going on this. This isn't going to be very long. I might go back and do another live stream just to chit chat on screen. I can't figure out how to get this camera showing me and then flipping between my display. So You'll just have to trust me that I'm here. If it sounds okay, then that's good. But I want to be seeing something different than what I'm seeing on the screen. And it has to do with this app here. Yeah, it's probably just a matter of clicking on one of these buttons. If anybody out there knows, yell it out in the chat what I'm doing wrong. But in any case, yeah, there was a request to go over the Rule 122H material. And so, yeah, let's get rid of this. Let's show this. And in actuality, the best thing I would refer you to, I've put this link before, but this is the Arizona Courts.gov, Arizona Judicial Branch Court Rules Forum. And so there was a proposal to amend Rule 250031, or that's the name of the number of the petition. R25-0031 is the petition to amend Supreme Court Rule 122. And it was proposed by our good friend, the Tucson Principal Assistant Prosecuting City Attorney Matthew A. Walker. Matthew Aloysius Walker, or whatever that A stands for. So he's of course a public servant. I don't know if he was elected to this position or placed in this position, but as such, he's a representative of the Arizona courts, a government public figure. So we are covering this amendment to Rule 122 of the Rules of the Supreme Court of Arizona to broaden the power of a court to restrict recording or broadcasting court proceedings. And so there's an opportunity for the public to comment, and they must be submitted no later than May 1st, 2025. And any reply by a petitioner, and the petitioner is Matthew A. Walker, any reply by a petitioner must be submitted no later than Monday, June 2nd. So members of the public can go to this link here, to the frequently asked questions, and then it's going to take you to, well, let's just click on that. What is this? Oh, that's a proposal. So at the top of the page that let's see here. So over in the chat, at the very top of the chat box, I posted the link to the page that I'm looking at right now. This Arizona Courts page with this kind of cover page here. And then we'll click through these different documents, and it'll show you how you can respond to this. And yeah, Laura Conover is involved, and all these other delightful people here. And so this is something I had discovered shortly after New Year's. I just kind of stumbled upon it. But yeah, first things first. Let's go over here. Frequently asked questions. So it says you're going to scroll down. Who is entitled to comment on a Rule 28 petition? So we're going to click on that. Anyone can comment. Submitting a comment. So you have to log in as a registered user to oh, it's been a while since I was on this page, so I can't remember the process. So you have to register with this website in order to submit a comment. We'll go through that. I'll figure out how to do that. Or you could contact by phone, but oh, actually, I think let's go. Rules forum. Okay, these are all the different rules in the Arizona courts on the court rules page. Yeah, so if you want to register, I guess go to at the FAQ page. Let's see, were we there? Did I just miss that button? That's the forum FAQ. Where did I find this from? Arizona Court Rules Forum. Arizona Court Rules Forum. Good grief. Let's see this. We'll go back. Court Rules Forum. How did I find this? Yeah, in any case, you'll have to register an account. And I'm up here in Canada, so I don't think I'm going to participate in this. But basically, you register an account at this sign up. So you got to give them some basic information there. And then, yeah, let's go back to this page. This page. Let's say what? Oh man, let's do that again. Let's see if I can find it by doing this. Petition, there we go. Oh, okay, so this is the PDF actually. So yeah, we may as well read this while we're here. So petition to amend Rule 122, Rules of the Supreme Court. Pursuant to Rule 28, Rules of the Supreme Court, Matthew Aloysius Walker respectfully petitions this court to adopt amendment to Rule 128, Rules of the Supreme Court, governing recording in courtrooms for the reasons set forth in this petition and as proposed in the contemporaneously submitted appendix. So the background and purpose. Rule 128 permits recording in a courtroom. However, this rule and one paragraph in particular has been misused. Oh no. If not openly weaponized by individuals who are live streaming court hearings on the internet to intimidate and harass others who are appearing or testifying in court. So that's kind of an unsubstantiated claim. That's conclusive. If you want to use the terminology, it's up to Matt to prove that this is happening. So Rule 122C states that except as provided in paragraphs H and I of this rule, a person who wishes to use a recording device during a proceeding must submit a written or electronic request to cover the proceeding to the judge. So we're not going to go look up the original rule because he's basically given it, or he's quoting it here. So rule and you could look up Rule 122C on this same website that we were looking at, and it's got the existing rule, and that's basically what he's quoting here. And then must submit a written or electronic request to cover the proceeding to the judge. So a party, victim, or witness may object to this request. See generally Rule 122C 4 or 5, and the court may deny coverage under 122D. However, Rule 122H states that a person may use a personal audio recorder during a proceeding, but the person must notify. So there's a difference between getting permission, must submit a written or electronic request, but if you're recording it for your own use, whatever that use may be, you just have to notify the judge or the judge's staff prior to using a device. And this is where all that Judge Ball ridiculousness came in, and every hearing that Lane was attending in relation to the O'Reilly stuff and the Deloria arrest and Mackenzie O'Brien and all these other alleged witnesses or victims who wouldn't even show up at the hearings or wouldn't answer subpoenas. They went through this on every time he appeared in court, and basically kept wasting the court's time for something that was already established numerous times over. So Lane would go into the court with his recording device, no video, just audio, and then he was using it to record the proceedings because, as we know, the court is not obligated to provide you with a record of what happened. And even if they say they're interested in that, well, sometimes they forgot to hit record, or that file got erased, or they can't find it, or this reason or that reason, whatever excuse. So Lane, he records everything. And so by this rule, 122H, he was notifying the judge or the staff that he was using the device, a personal audio recorder during a proceeding. And Lane has gone and argued, what is an audio recorder, personal audio recorder, and does that cover this? Does it cover that? And Lane has covered this in videos on his channel. And but that's kind of beside the point. I'm not here to make a ruling, but I just wanted to show you this is what Matt Walker is proposing here. So as long as the device is on your person, so not required to submit a request under paragraph C, but a person who wishes to record or broadcast the audio portion of a proceeding with a device that is not on the person must submit a request. So read collectively, paragraph C and H, this is Matt arguing, appear to allow a person to record or broadcast a proceeding without the person even needing to seek the permission of the court, as long as the recording device is on their person. As a consequence, individuals attending court proceedings have been using smartphones to broadcast, i.e. live stream proceedings without requesting permission from the court, and judges seem unsure as to whether they even have discretion to deny the request. Again, discretion to deny when a request is not required. This is where I guess he's wanting the Supreme Court to weigh in on this. Because, I mean, just think about it, folks. If there's nothing to hide, what does it matter whether a news outlet, whether it's ABC News or CNN or Lane Meyer's Freedom Productions LLC or whatever his media company is, or any other entity on or off planet Earth somewhere within the known universe decides to broadcast what's going on inside a courtroom. I mean, they're recording themselves. They will live stream to YouTube or other platforms as well. So it really is kind of a moot point as to why would you be so concerned about someone recording and or broadcasting their own case. You know, they're potentially giving permission, and whether Arizona is a one-party, two-party consent state as far as recording, well, you're in court. There's a court recording. There's a court recorder who's making a transcript, and so the camera or the audio is just yet another record preserving what took place, and it prevents this he said, she said, or we lost the transcript, or they don't get the transcript to you in a timely manner. And as you've seen Lane's situation, he's been juggling numerous cases at any one time, and so to stay on top of all these court filings and communications with the court clerks or court staff, requesting transcripts, requesting this, like it needs to all be done in a timely manner. But when you're juggling 5 or 6 or 10 cases or however many you had on the go at any one time, it's just so much simpler to press record or press stream on your device, and then you've got the record. Like, there's no fighting over it. So, like, what is the court, or what is Matt Walker worried about people seeing if the system is legit? And this is kind of the whole controversy, if you will. And so the court of public opinion, I think, you can tell by my tone where I stand on this, but it seems a lot of people in the court of public opinion need to realize what's going on and allow them to decide. Like, if recording is allowed anyway, and the court itself, Arizona courts, whether it's the city or Superior Court or district, doesn't matter. If recording is occurring, what does it matter if there's one more camera or one more device capturing the audio? So anyways, let's read on. It just smacks of, it doesn't pass the smell test why this is such a concern. Is it protecting the victim or the plaintiff? Like, is the victim or plaintiff going to require that the court not take a transcript to protect their privacy? Like, it's a public hearing. So it's just kind of nonsensical on the face of it, in my opinion. So you can tell me how right or wrong I am about that. But in any case, let's just carry on reading. And yeah, I don't know where we're at with the chat or whether this is still even streaming. But we'll just carry on, and if I have to redo this, I'll redo it. So this is particularly problematic where the live streaming is used as a mean to embarrass or harass. So what if it has nothing to do with embarrass or harassing? What if it's just preserving the records so that you don't have to fight with the court clerk and go back and forth? Like, it's just a nuisance to deal with. This is the whole thing. It's like we're not getting the service we're paying for with our public servants. And so if I could do the job and preserve a court record for my use, what does it matter? It's an extra email that doesn't have to get sent, read, or answered. Like, it really streamlines the process and takes pressure off the court clerk if they're not having to answer requests. And then, with Lane, if he doesn't get access to what he's asking for in a timely manner, that's when you get the full Lane Meyer effect, and it comes across as harassment. But all it is Lane standing on his rights and demanding that they provide the service that they're obliged to provide. And they're the ones that made the rules, not Lane. He's just trying to make them. He's enforcing their own rules. Like, we didn't write the rules; they write the rules. But they seem to be at liberty to break the rules at will when it's convenient. We don't have that power. Like, there's a power imbalance, and this is what people like Matt Walker and others don't understand: is there's a power imbalance, and people are worn out. They're sick and tired of it. So again, my position is Lane is in a heap of trouble right now. Like, he's kind of dug himself a hole. I don't know procedurally how this is going to play out because they've got him where they want him. But in any case, this is specifically 122H. And so this is an attempt by Matt Walker, what appears to be, to shut down people's ability to make a public hearing as transparent as possible. Like, somehow that's an offensive idea, and that doesn't make any sense. So, court of public opinion, feel free to participate in this process, which we're going through, as you see fit. So it may be argued, embarrass or harass another person, such as a victim in a criminal case or a party seeking to have an injunction against harassment upheld. So there's a footnote. See, for example, Lane Myers wins 2 cases in one day. So he's trying to use Lane himself to argue his point. And Lane has said, so suppose I mark this link as private. Your whole ability to argue has been taken away. So I don't know if Lane has, I don't know if he has. I guess we could look that up right away, but on his channel. But Matt Walker went to the length of using Lane, singling him out as the reason for this rule amendment. So again, this sounds like lawfare to me. Why can't Matt Walker speak in generalities? He's got to specify there's one particular individual who's got under his skin and publicly humiliated him in front of a judge, Judge Rojas. I mean, I'll probably put a link to that video again. That one is linked on my Twitter account. So if people want to go check that out, go find me on Twitter. It's the same handle, Brent Shimko. And that one is somewhere on my page. And that one is Lane Myers eats a prosecutor. I think that was the very first live stream he started doing. Before that, it was all just videos that he had pre-recorded and then would post. But that was a live stream he did from court, and he follows up after he's outside the court. So there's a little bit of video at the end, and that one is very entertaining listening. So that's a good one to go back. I'll link to that somewhere on this video. So the rule is also silent as to protective orders proceedings specifically. So yeah, apparently big problem. So who do we know that's got an injunction against harassment that also happens to possibly involve Lane Myers? I'll let you fill in the blank there. So is it possibly anybody connected to Matthew Aloysius Walker? So it may be argued that paragraph H only permits recording for personal use later and not live streaming, although the second sentence in the paragraph referencing broadcast appears to undercut that. So he's admitting, like, yeah, I don't like it, but the rule actually does allow this behavior to take place, and I don't like, it sucks. But so if this is the case, the rule must be clarified. Because that's what we need, clarification. Like, it's just so ambiguous. I need to know if I'm being recorded in court or not, because that'll determine, what I say or do, or how much truth I'm willing to allow. But in any case, Arizona appellate courts provide no clarity in this regard, as paragraph H does not appear to have been analyzed or even cited in any Arizona decision. Federal courts have referenced the rule. See, for example, blah, 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 but have not addressed the broadcast component. The ubiquity of smartphones and live streaming services have created an issue that simply did not exist even a decade ago. Yeah, well, get with the program, get with the current year. It's 2025. Everybody's got a camera walking around with them, and if you're in public, especially a public forum like a hearing, that's a matter of public record. Why are there tears being shed over this? So this is an issue. One that will only get worse unless and only unless courts feel empowered to address it. Well, it seems like it's been addressed. This seems like a certain prosecutor with the last name Walker is just a little butthurt here. So in that vein, it may seem self-evident that a judge always has discretion to allow or not allow recording. This court has cited Rule 122 to that effect. The trial court has broad discretion in permitting electronic, broad discretion. But again, Rule 22 does not by its terms give courts that level of flexibility. If a judge has discretion to permit or deny recording or live streaming, the rule should state that. And there is no reason that the judge should not have complete control over whether that occurs in their own courtroom. This petition recognized that a defendant's interest in a public trial, as well as rights of both the public and the press to attend trials, are substantive and fundamental. Period. That should be it. You just argued against your own position. Let's crumple this petition up and throw it out, because the defendant's interest, the rights involved of the public, the press, blah blah blah, it's a moot point. However, so there's always a however or a but. As noted, a court retains or should retain broad discretion as to whether to allow electronic and photographic coverage of proceedings. And really, these rules are so to maintain decorum. It's not to protect witnesses. It's to maintain an orderly atmosphere and conduct in the court. If you had like back in the old days with flash photography and 20 newspapers crammed into a courtroom in the gallery, snapping photos and flash photography, like that's why they have courtroom artists that do drawings. They don't want that disruption and that hoopla. Like they don't want to turn the proceeding into a circus. And so, I mean, raise your hand or put a 1 in the chat. Hi Bev's channel. I'm reading the petition by Matt Walker to amend Rule 122H, which allows recording of court proceedings. And this was submitted to the Arizona Supreme Court by Matthew Walker, Tucson City assistant prosecutor or something or other. And so I've just been going through this document that he's proposing that the Supreme Court is going to make a decision on. And so there was a request by one of our loyal viewers. Sylvia had asked to go through this because it seems like something that was a little forgotten. And now that Lane is where he is, he doesn't have the ability to challenge this. And so it's kind of up to the public to deal with this. So I don't know, are you in the United States or where are you from, Bev? In any case, I'll finish reading this document and we can there's a couple more things I want to show you on the screen. I can't get my camera to work as far as showing me with the presenter software that I'm using, the app, but whatever. So where were we? So yeah, we're at the point where Matt Walker is acknowledged the people's rights, the public's rights, the press's rights, the defendant's interest. But yeah, your smartphone, your iPhone, your Android device, it's not going to be disruptive if you click record and stick it in your pocket. And so even the idea that you can't video record, like some judges, they just freak out over this. No video record, just audio only. It's like, what's the difference? Like the whole thing's being either, like there's cameras everywhere now. Like the idea that there's such a thing as privacy anymore, like that's gone. Like forget about that. You have no privacy, so just deal with that. You're in the U.S. Okay, good. So this is, well, Matthew Walker. No, he's done, but he's not done. Let's just put it that way. So, because this is his proposal to amend this rule for recording in court. So carrying on. So from this reference here, so he's arguing courtrooms should not be considered a forum for First Amendment expressive activities. I don't know. That's a stretch. I think that's been there was that California case. I know American, I know Canadian case law, and I think it was pretty clearly established that you can say what needs to be done. The courtroom is a place where the First Amendment does apply, as well as even freedom of speech. So, but then the last bit of it. So, public interest in television access to the courtroom does not now lie within the. I guess he's referencing some of this. So, again, it just seems he's got the weakest arguments. Really just grasping at straws. Maybe, I think the whole system is gamed, and that the Supreme Court will be convinced, unless there's an uproar. So yes, this goes back to the Riley case, and there was a number of prosecutors switched over, and it's not for any particular case. This is for a change to this Arizona court procedure rule. So kind of once I get to the end of this document, we'll go back and maybe it'll start making more sense to you. So open court broadcast. Let's see how much more of this drivel there is. Okay, only another page and a half. So. It may be argued that open court and broadcasting constitute a distinction without a difference, but open court proceedings and the number of people who can attend are not necessarily circumscribed. Descriptions that occur after the fact are more dispassionate and measured as a judicial process itself should be. It is one thing for a victim or witness testifying to a I mean, he's just going on and on and on. I'm not even going to read this. So finally, we get to the point. The petition does not seek to change Rule 22 to prevent recording or live streaming in court altogether. Obviously, an audio recording is required in almost every court proceeding, and many proceedings are live streamed in the post-COVID era. Oh, yeah? And so live streaming or virtual hearing court litigants and others who simply wish to take in the justice system as a matter of public record. Yeah, we all understand that. But maybe you don't, Matthew. But whether recording or live streaming does occur must be at the sole discretion of the court, not at the discretion of bad faith actors. Oh, so let's bias the Supreme Court by labeling people as bad faith actors who aren't going to be there to testify on their own behalf. Like, what kind of bad faith actors do you have in mind? Anybody specific? These bad faith actors, their only interest in live streaming is to embarrass or harass others. Yeah, it's not to preserve a record so that they have to fight with the court clerks for a record of what happened. No, it's not that. It's not recording public officials and public servants and public employees every time you encounter them, because their track record is abysmal for providing you with the service you're asking for. And whether it's a judge or a prosecutor or a public defender, like, it's in your best interest to record them every opportunity you get, especially in your own matters. Like, Matthew, why do you hate America so much? Why do you hate freedoms and liberties so much? I don't know, shake my head. SMH. Judges should use, where are we? So yeah, bad faith actors, all they want to do is embarrass or harass. So he can read people's minds apparently, and he's assuming the Arizona Supreme Court will trust in his ability to read people's minds and attribute motives to what they're doing. It can't be anything other than evil people doing evil things. So moreover, it should occur only after the party to be recorded has had the opportunity to be heard on the issue, and after the judge makes findings. So yeah, it's just defer to the black robe tyrant. Judges should use their judicial authority to protect victims and witnesses from harassment, threats, intimidation, and harm. I respectfully urge the court to adopt the amendments in the attached appendix. If the court does not, I respectfully urge it to clarify in some manner that judges, for my sake, please, won't somebody think of the children? In some manner, the judges retain absolute discretion as to whether, respectfully, piece of garbage, this, whatever, Please, yes, please accept this drivel that I've written on this piece of paper. All right. So that's his proposal. And the appendix goes into the details of the wording of the current law. And let's see if we can find it, or if this is going to take forever here. Proposed local rules. So we're on the Arizona Courts.gov. So this is a government website. And proposed local rules. That's not what I want. No, that's the same page I'm on. I had it before. I don't know. I'm just gonna have to go like this. I'm not used to using Windows computer. I normally do this on a Mac, but this presenter software is only on my Windows computer, so bear with me as I remember how to do stuff on Windows. I can't even remember how to get the history. Okay, let's just go like this. Do Google search. I had it before. And I type slow, I hunt and peck, so your patience is appreciated when I'm doing these kinds of things here. Okay, so here we go. We were at this page before. So, yeah, a little nuts to call everyone evil, but he painted pretty much anyone who walks into a court with a camera phone or a smartphone with the intent to record their proceeding or record any proceeding as a bad faith actor. Like, he's just attributing that to whoever shows up to do that. Like, that's ridiculous. Absolutely ridiculous. So this is the petition. Here's the appendix. So What is this? Let's do a PDF. I don't trust this thing. What happened? Did it download? What happened? Should I just download it or not? Downloads. Ah, here we go. Well, just open it, man. I don't know. I don't care. Let's use this. Okay, so I'm sorry if this is super dry. This is like painful for me, but so rules of the Supreme Court. This is appendix to what we just read by Matthew Aloysius Walker, the assistant to the prosecutor, or Tucson or something or other. So use of recording devices. So Rule C is a request to cover a proceeding. So that was mentioned. Paragraph 3, court action upon receiving a request. Number 5. So these are all referenced in the preceding document. Denial, limitations. And so H. So this is the juicy part. So personal audio recorders required notice. So he's struck through the word notice and wants the Supreme Court to have required request to the court. So a person may use a personal audio recording during a proceeding, but the person must, he struck out all of this. This is the old rule. The person must notify the judge or the judge's staff. So we're going to scratch that little part out of there, forget that even exists. And so you can bring a personal audio recorder during a proceeding, but the person must submit a request pursuant to paragraph C prior to using a device. And that's going back up here, which is this, a request to cover a proceeding, right at the very, very top. And so we're going to get rid of this part too. It used to say a person, or it currently says, a person who uses a personal audio recorder is not required to submit a request under paragraph C of this rule, but a person who wishes to record or broadcast the audio portion of a proceeding with a device that is not on the person must do so. So meaning if it's in your hand or it's in your pocket, you don't have to submit a request. But if you're setting up a camera in the corner of the courtroom, and then you're going to sit at the bench, or you're going to sit, in the witness stand, or sit at your table. Well, I guess you wouldn't be sitting at the bench. That's where the people in the black robes sit. But if you're setting up a camera that's not on your person, you have to submit a request. But if it's on your person, you could just notify. So they want to get rid of the notice and turn it, make you ask permission. And then this whole thing I just read, they want to scratch that and replace it with a person may not disseminate their personal audio recording of a proceeding to the public without the permission of the court. Again, what are you afraid of, Matt? Like what is going to get out there that you are so afraid of? The use of so this would replace all that this is struck out here. And these are Matt's notes here. This is his proposal. This is what he wants to see. And this is going to be heard before the Supreme Court, I believe sometime in June. I'm just going by memory. Like we're not done yet. So the use of a personal audio recorder must not be obtrusive, distracting, or otherwise prohibited. I guess you're not allowed to attach an air horn or a siren to your personal recording device to make it like who's going to do that? And is used as this is part of the existing rule. So yeah, duh, it goes without saying. The court does have decorum. You want to maintain that decorum and not be disruptive. Like, yes, that has nothing to do with what Matt's talking about. He is trying to obscure or prevent transparency. That's how it appears to me. We see you, Matt. We see you. The rest, part M. And that's basically it. So it's this paragraph H that is the alteration to what he's wanting to do. So do I still have this? Yes, this is here. So now let's get to this part. Opening rules for public comment. So this is a PDF. Let's open this. In the matter of these are the proposed, I guess, changes to rule petitions for public comment. And so this was filed on January 1st of this year, or January 21st of this year. So rule petitions have been filed in the above captioned matters under Rule 28A, Rules of the Supreme Court of Arizona. Upon consideration, it is ordered that these petitions are open for public comment pursuant to Rule 28C, Rules of the Supreme Court of Arizona. Comments must be submitted by no later than Thursday, May 1st, 2025, and any reply by a petitioner must be submitted no later than Monday, June 2nd. So meaning, if you're aware of this rule change that Matt Walker is petitioning, he's the petitioner, and so all these other different rules are different amendments or proposals to change the rules. And so our rule is, I forget which number it is, kind of not important right now. But if you're wanting to comment on any of these rules, I mean, you can go back and look at them on the arizona.courts.gov page. And so there's a process to make your comment. You could say, I think this rule sucks and Matt Walker's hair is awful or whatever. I mean, be respectful, like be relevant, be addressing the rule. And so in any case, there's a process. So there's even is this a hyperlink? Yeah, you can link right from this document, which I just opened, this PDF or whatever this is. So then Matt Walker can respond to any of your comments made by the public and kind of address them one by one, I guess. That's his prerogative. The petitions may be viewed by going to the rules forum. That opens the welcome page. Petitions are posted. And so, again, the petition is what Matt Walker submitted. We just went through, including the appendix. So for instructions on how to post comments electronically, this is where your part comes in if you want to make a comment regarding what we just read. Follow the steps listed above and click on Arizona Court Forum FAQ at the top of the Forum FAQ page, and then how do I file a comment on a Rule 28 petition? So before I close this, alternatively, commenters may submit comments by filing an original and one paper copy of the comment and one electronic copy of the written comments, and supporting documents in Microsoft Word format on a CD or other compatible electronic medium with the clerk of the Supreme Court, and they give the address. Any person filing a comment must send a copy of the comment to the petitioner electronically or by ordinary mail. So this was dated the 21st by Jean R. Lopez the 4th. So yeah, so basically they're using. Uh, shut this down. How do I shut this down? Get this out of here. How do I get rid of this? I'm done with you. Oh, here. Shut that down. So yeah, this was the page that's got all these links to it, and that is the one that's linked right at the top of the chat box. It's the pinned comment there. So if you click on that, it's going to take you to this screen, and then from this screen, you can register to make. But here's the FAQ. And so if you click on that, it'll take you to, well, let's click on it from here. So go to FAQ screen. And this is going to be, how do I comment? How do I file a comment? So then you have to follow these directions. And so this is the platform you make your commenting on. And as I said, I'm Canadian. I don't feel too inclined to, meddle as far as weighing in officially with the court. Like maybe that's cool with you guys, but I would just assume not. I don't even know if I would be allowed to set up an account with the court. So it's kind of a moot point. So this is kind of by Americans for Americans, and I think that's kind of the way it should go. Like I don't want a bunch of Americans weighing in on stuff that actually is happening here in Canada, unless, not through these official channels. We could do it through unofficial channels, but if you get my meaning. And so yeah, if you're wanting to comment on what Matt Walker has submitted, this piece of garbage petition to the Arizona Supreme Court, then respond in this manner. And so yeah, you'll have to set up that, like register an account or register with this website by clicking this button. Let's just see what happens when I click that. Oh, I think we clicked this already. So yeah, you'll have to basically register, which I'm not going to do, but you can if you're in the United States. And proceed from there. Is there anything else I wanted to say about this? Proposed local rules. Let's just see where this takes us. This content, what? Takes us right to Westlaw. All right, never mind that. That's not what I wanted. Pending rules? No, that's not it. Anyways, there's someplace on here. Let's see. Rules. Here. Is it rules for? Let's click on this first. See what happens. No, that's right. Same place. I think it's. Some of these sites are just not user friendly at all. So here's all the different rules that they're proposing to be changed. And I guess who submitted them? I believe. Rule change petitions under consideration. Yeah, so. So you could scroll through this and just see what other rules you're not pleased with. And like there's a cutoff or a deadline for when the Supreme Court is going to hear rules for that year to be amended. But in any case, Matt Walker's rule is in here somewhere. I forget where. So it's kind of whatever. Not important. If you want, you can dig around on this Arizona website. But in any case, Matthew Walker, yeah, Principal Assistant Prosecuting City Attorney, disclosure and its contents. And this is a presentation using disclosure as a sword and a shield hidden behind a paywall. So again, where's this site? Oh, Arizona Prosecuting Attorneys Advisory Council, part of az.gov, which is a government site. So stuff that government officials and public servants are doing to serve the public is hidden behind a paywall. So just a heads up, if I were you, I might, if I was in the States, submit a public records request for this to be removed from behind the paywall so that everybody knows what Matt Walker is talking about in these continuing education seminars, because he's talking to other prosecuting attorneys. And he's got an hour-long presentation or whatever this is, 56-minute presentation on how to use disclosure and the rules of disclosure to better prosecute bad actors and evildoers alike. So, principal assistant. Let's see what it says about Matt Walker here. He's a principal assistant prosecuting city attorney. Sorry, I'm not dull. I just got bad eyes. I can't see my screens. Tucson City Prosecutor's Office. Matt Walker is a prosecutor with the city of Tucson. Oh, very nice. You don't say. When he is not responding to motions, he can be found yelling, "No!" at the top of his lungs while watching University of Arizona sports. So it seems that Matt Walker has a bit of a possible rageaholic, needs an intervention here. He's a rager when it comes to University of Arizona sports. I would probably watches University of Arizona events while sipping on Bud Light. Mr. Walker lives in Tucson with his wife. Oh, this is a public website. So he discloses who he's married to. He discloses that he has 2 children. And he also has 2 bad dogs. Well, why would you get yourself a couple of bad dogs, Matt? Why wouldn't you get good dogs? Oh, well, it's because there is no such thing as bad dogs, just bad dog owners. So that's why you have 2 bad dogs. A little bit of self-reflection might go a long way, Matthew Walker. But enough of that. I'm sick of talking about Matt Walker. These people just absolutely... You're not going to get through to these people. Lane himself approached them and said, "Hey, no hard feelings. I'm not doing this to be a bad actor. I'm doing this because I believe it's right and I'm standing on my rights, and all's for war kind of thing. Like let's agree to disagree that this isn't harassment, this isn't criminal, this is just the way I roll." And they interpreted that as harassment. So Elaine's gone through it in all his videos. For a full treatment, for the full Lane Myers effect, did I link this? I think I linked to this, holy smokes, either in the community post I made, or I'll link it somewhere on this video as well, this live. But this is going back to, well, this was just after the new year. And so I had all this information that we just went through. I stumbled across it sometime in January. I forget when. And Matt, on Lane's channel, he was going through like the Newaygo County stuff in Michigan, and he was starting to revisit some of the stuff that was going on in New Mexico because that case was coming up. And then I sent him a link. I said, "Hey, bud, have you seen this?" And he's like, "What the fuck?" You know, I wasn't there to see him when he opened my email, but he's like, "What the fuck is this? Where did you find this?" And I said, "On the internet." Like, and so I guess he was distracted, wasn't aware that he needs to watch Matt Walker like a hawk. And so I sent him the link to the Arizona.gov or ArizonaCourts.gov site, gave him the link and said, "Here, have fun with this." And so he did this live stream where I think this live stream and the next one, so consecutive. If you go on his playlist, again, I'm going to be linking to this, and he goes through this 122H proposal, the amendment, and yeah, whether I guess harassment is in the eye of the beholder, and so I mean we can discuss what Lane does is 100% harassment. I don't see it that way. I see Lane as having a perspective where he's standing on his rights, and it's going to be about, I don't want to say half and half. People will agree with Lane versus what will agree with the prosecutors and the victim in this case. But in everything I've seen, to rise to the level of criminal harassment, I'm just not seeing it, and to the point of keeping him in jail without bond because he's such a risk to be at large. I'm not seeing that either. So that's why I'm calling Lane a political prisoner at this point. And yeah, I mean, calling me wrong, that's not going to bother me. I'm not offended by that. Like, I'm open to hearing more of your evidence that I am wrong and that Lane's wrong and that the Walkers are all right in this case. But just what I've seen with this amendment to 122H. Well, okay, in this video that I have up on the screen, Lane gives his reaction, and it's sort of like the dam breaking loose. Is like, okay, we've got Matt Walker now right where we want him, because this is out. Like he's crossed the Rubicon now. Like there's no turning back. And so this is one of the matters that Lane was asking people to address, asking people to comment on this by following the procedure that I just laid out for you. So so I'm just wrong. Well, I guess I'm just wrong then, and I guess we'll just leave it at that. So end of discussion. I'm wrong, and yeah, if Americans want to weigh in on this, just understand that I'm wrong, and proceed as you see is appropriate. But the reality, Bev, is that people are in agreement with Lane and are in agreement with what I've just said for the last hour or however long we've been streaming here. And there's people that are going to be, wholeheartedly opposed to the things I'm saying. Like it is a matter of perspective. It is a matter of your worldview, whether you find yourself, wanting to, how you interpret what human rights are and basic civil rights and constitutional rights are. So it can come down to a difference of opinion. But it's more than just saying you're wrong and I'm right, or I'm wrong and you're right. There has to be room for a nuanced discussion. And what I've seen from Matt Walker is this is retaliation for being humiliated in front of Judge Riojas, however you say that, pronounce that name. and just the way they've been handling Lane's cases. It's being tossed from judge to judge, prosecutor to prosecutor. Parvin, yeah, Jason Zwack has been doing a number of breakdowns, and everything Jason is saying is more or less correct and true, but I don't know if it's going to make a difference. Like, they've got Lane between a rock and a hard place. So how do you go about getting yourself out of that position? In the end, Lane's got to do what Lane's got to do. But this video here that I have up on the screen, which I'll be linking to, that goes through from Lane's perspective what his take is and whatnot. So he mentions me by name in this. And watching this was a load of fun. Like, I wasn't expecting this reaction, but it was kind of cool to be part of the Lane Myers People's Army peaceful movement for social change. Like, it was just me doing my part, and it was really a chance happening that I came across the material I came across, and I just naturally forwarded it to Lane because it directly affects something that's of interest to him. And so where this is at now, I don't know. I'm not going to be quarterbacking what happens beyond this point, really. Like, I'm basically just doing this live stream at the request of Sylvia had reached out and said, I guess you wanted clarity on what was happening with this 122H because the time or the deadline to submit your comments is coming up in less than a month. So if people don't comment and the Supreme Court of Arizona hears it and makes the change to 122H, then people won't have the opportunity to record their own hearings or any proceedings without requesting permission. And the current rule is you don't need permission, you just need to notify the court that you're going to be recording, and that's sufficient. So again, why Matt Walker is so opposed to that, one can only guess. It doesn't seem to fit with the First Amendment of the Constitution, and so do with that as you will. And with that, I think I'll shut this live stream down. My voice is starting to give out anyway, and we'll do a regular live stream tomorrow. I don't think I'm going to go and do any more streaming tonight because it's been a long day. We had a piggy rodeo here earlier. We were wrestling with some pigs, tossing them in the back of a trailer, and these were big chunky boys. And I'm going to be getting a good night's sleep tonight because I'm exhausted from wrestling with pigs. Not the two-legged kind, but the four-legged kind. So that was a workout, to say the least. So if there's no other questions or comments, you're in a bubble. Crazies, literally 99%. Yeah, I would agree. Some of his conduct is nuts. But even people that are nuts have rights. And so he's made his case clear through possibly 1,000 hours of streaming and video making that he's not coming from a position to harass. He believes he was doing the right thing and that he was following the law. Lane nicknamed himself Lane Walk the Line Myers, and this is where he believes he understands the law as it's written and he stays within the boundaries of the law. Now, in my opinion, there's the law as written, which to me is the law in theory, and then there's the law in practice, or the law in application, and that's the real life. And so where Lane finds himself now is he's encountering the law as applied in real life, and the system is coming against him, and all his idiosyncrasies and claimed disabilities are not going to help him at this point. So again, Bev, that's kind of your opinion. Like, the laws are written, and I understand that the game of the law or the application of the law is something that Lane is currently embroiled in. So we are going to disagree on these matters, and that's fine. There's other ways to deal with the civil rights and constitutional rights, and we're going to explore every option available. Lane sees everyone as beneath him. He has absolutely no respect for the law. Yeah, that's where I disagree with you. He's where Lane and I disagree, or don't see eye to eye, is that Lane is a statist. He trusts that the justice system is going to see and recognize that he has done nothing wrong because he's made his best attempt to adhere to the laws as written. Well, as we're finding out, it's not the laws as written, it's the laws as felt. There's so much emotion and feelings I feel about this. It's harassment. Well, that's very subjective. The law is an objective matter, and so much subjectivity has crept into these matters. Like I'm not going to sit here and litigate Lane's position, but this is my observation as a Canadian tuning in. I wanted to see if Lane, as a statist, could use the system's rules and get justice. And it appears that that is no longer the case. That is not accessible to the citizenry. The system is going to do what it wants. And Lane does have a fairly astute legal mind and an attention to detail, but he's not an experienced litigator. He's not able to argue his case well because of his idiosyncrasies or his eccentricity or whatever you attribute to being effing nuts or being, this, that, or the other. But that's beside the point. Lane believes he should have access to justice and that he should not be behind bars. And if the system operated as it claims it does, where justice is blind and there's one law for all, well, it appears there's not one law for all. It seems that there's a club. And if you're not in that club, there's different rules for different people. And this petition is evidence that there's a Lane Myers rule that they're trying to bring into the Arizona courts. And if they're successful in doing that, well, then people like Bev and Bev's channel are going to be happy. I think you're in Australia. Bev's? No. I looked up your channel. Just because at one time you were a Lane Myers supporter, were you not? Or a follower. And I remember seeing you in live streams in any case on Lane's channel. But the reality is there's rules, there's laws that we're all expected to abide by, but if you're in the club, those rules don't seem to apply. And so I am much more of a voluntarist, anarchist, agorist, that persuasion, in that I see that the system has been corrupted, and it comes down to power and a lot of times money. In this economy, money equals power, and there's the old saying, power corrupts and absolute power corrupts absolutely. And so what I see is an abuse of power. This whole petition is an abuse of power against an individual, in particular Lane Myers. You're saying no, well, go do a live stream and I'll come in and see what you have to say. Or maybe I'll have a panel. Once I can figure out how my streaming works, I'll get Streamlabs on and you can say your piece. But you've already condemned Lane Myers, and I don't see that that's fair. But all the indications that I see is that Lane is getting railroaded. And many people see that it's not that he broke laws, it's that he allowed the system to use procedure against him. And so he hasn't been able to submit evidence. He hasn't been able to get on the record anything that has come out of his mouth. The judge or the prosecutor has managed to sweep that all away. So his record of the account of what's happened up to now in all these hearings that I've been following, he's not getting anything on the record, and that's a big problem. So that long drawn out no, I mean that's not enough. You're gonna have to give me more, Bev. So in any case, with that, I'll put links in the description of this. Not this. In my live stream. Let's see where we're at. Are we still even streaming? Yeah, we're streaming. So I'll once I shut this down, I'll add the links as needed. And if you're watching this after the fact, or your last name happens to be Walker, hello from Canada. We're watching you. We're not happy with what's going on in the courts in Arizona, especially in Tucson. It looks like a kangaroo zoo over there. And that's just my opinion. That's how I feel about these things. So, yeah. I'm supposing I'm still streaming, but who knows? It seems to be kind of replaying here. Or it's lagging or something. Oh. Regardless, somebody's hearing what I'm having to say and following along. I'm not going by what I'm seeing in the streaming. I'm not going by what I see here. So I think I will just give you the last word. You asked if I was ever a Lane Meyer supporter. That's what the long no was. Okay, well, I remember seeing you in his live chats, I'm sure. So if you were opposing him all along, I'm not ascribing the status of supporter or follower to you. I'm mistaken. So my apologies. But it just seemed that you were following his story, and this is just my memory. If my memory is failing me, then yeah, I'm not attributing anything to you. It's just from my recollection, I thought you were following Lane as supporting what he was doing, or maybe you were just following his interest. But you were in his chats, were you not? There, yeah, and yes, there is a little bit of a delay, so I didn't know what you were saying no to. But yeah, you're free to make the last comment there, and then I think I'll shut this down. And then anybody watching, leave comments. I can do more live streams on this matter. Like I say, I don't want to comment directly on Lane's case because I'm not a lawyer. I'm just an interested party. I wanted to see Lane prevail, but it's difficult to do. The reality is if you're not an experienced litigator, attorney / bar member, like, and you're doing it every day and you have a lot of experience, like you're going to get well, whether I give money or not, that's my business. Like, but I think I've gone on record. The only I haven't been contributing financially because I don't. It's not clear to me what his financial needs are at this point. And so as far as there is a legal defense fund, I do encourage people, if you so feel moved, to contribute to that. But I have set up the account to try to communicate with Lane on the app that reaches the Arizona Pima County Adult Detention Center where he's at, and I'm unable to reach him. He was able to send me one message, but I'm unable to reply back because my account or my status is pending review by the institution. So whatever, I paid the $10 to talk to him, and now I can't even talk to him. So it's not a big deal. It'd be great if he could use that $10 to talk to whoever he wants. I don't know how that works. The app seems really sketchy, and the whole system of justice and corrections in Pima County seem pretty sketchy. That's again my opinion. Hey, Dr. Osgood. I'm just kind of wrapping this up. Just having a back and forth with Bev's channel here. She's commenting. You were around last night, I think, for a little bit. Refresh me. Where are you from again? Are you in the United States, or what's your position on in the universe. What landmass are you currently residing on? Because I'm just doing this stream as a kind of a courtesy to Sylvia. She wants some clarity on this Rule 122H. What do I got to do here? I got to open a something or other. Rule 122H is the petition that, or the petition to amend Rule 122H that, what's his name? Matt Walker is trying to prevent people from recording court proceedings with their own recording devices for reasons. So I just went through all his filings, and if you're in the United States, you can comment on the Arizona court's website, so you can go back and rewatch. It's pretty dull, pretty dry stuff, and then I'll be linking to this channel where Lane himself was covering this matter, and this was back in January, a couple of months ago that he did this stream. Let's go back one screen. Nope. Oh, stay here, stay here. Where are we? Here. Yeah, all this stuff with this guy, I told Lane, just leave it alone. Like, it's just a distraction. I said it's not important, but I don't know. If you guys have been watching, you know what's going on there to some degree. But anyways, this is the video I've got on screen, and then I think he goes through the whole process here, which I went through in this video. And then he kind of carries on. So, but I think these two that have Matthew Walker in the thumbnail, those are the ones that will give you more background from Lane's perspective. I just read through the documents and made a little bit of commentary, and then showed how to go on the Arizona court's website. And if you're in the United States, you can register with that website and make comments to that petition, whether you're in favor of it or if you're against it. So go back, watch the rest of this video from the start. Do it at 2x speed, just so it's not so boring. And that'll give you background, and then you can go to Lane's site and look at the things he has to comment on that, and that'll bring you up to speed. And that's about all I have to say tonight. Like, I'm not too interested in commenting on the current situation because I don't have enough information to go on. Like, I don't know what's happening day by day. I don't know what Lane wants us to be doing. But at the request of Sylvia, who wanted clarity on this matter, I did this. So Sylvia, send me a message or leave a comment whether this was what you were looking for, or if I missed something or something isn't clear. This is about everything I know about the 122H matter, and I guess the clock is ticking in that you've got until May 1st to submit your comments, and then Matt Walker, the petitioner who submitted the petition, has a chance to respond to those comments to the Supreme Court, and then there's going to be an actual hearing where I don't know if it's a public hearing or if it's some secret hearing, but I think the Supreme Court will hear the case or the petition and make a ruling on it sometime in June. So yeah, do with that information what you will, but just understand by May 1st you got to have submit your comments. In this video I go back and look at how to do that. It's a pretty simple process. It's all done on their website. You can do it as well by submitting hard copies, but you also have to submit electronic copy. It's a pain in the butt. You can do it all through the website. So with that, Mr. Osgood, sorry you came late. You missed a bunch of legal jargon and mumbo jumbo and a little bit of commentary by me. So, but yeah, go back. That's all we were talking about is Rule 122H, recording in court hearings with personal recording devices. That's it. And so you can have fun with that. And so unless you have any questions right now, I am going to be shutting this down if I could figure out how to do that. This whole streaming in this manner has been quite the adventure. I was hoping to get my camera set up, but maybe next time. The light is on, but nothing's happening. So in any case, good night all. I'll do another live stream Sunday, which is tomorrow. So this is what? April 5th. I'll do one April 6th, probably an evening one. Sometimes I have the energy to do like morning or lunchtime as well as evening, but we'll see how it goes. I'll post something on the community posts to give people a heads up if I'm, if I'm scheduling, so you can adjust your schedule and be present. It is always more fun to have people to talk to. I don't mind just doing this and posting it, and then people can find it after the fact. That's fine as well. Rather than shoot this as a video and then, it's always more interactive if there's chats going, and then we can address questions as they come up. But in that case, I appreciate your appreciation of my videos. We'll keep doing these as long as it still makes sense to do so. And yeah, if you have any questions, like I've got a background on Lane's situation. It's just what's been happening in the last 3-4 weeks. It's just gotten too chaotic for me to follow. And without knowing what Lane wants us to do as a strategy, other than he's said explicitly, like, don't post videos harassing the victim. And so I've got a big warning in the description of this, or there will be a warning, caution, clicking on this live stream will open you up to potential criminal or civil charges. Proceed at your own risk. So this video is not meant to harass. It's meant to inform, if not do a little bit of trolling, but it is definitely not harassment. If it's seen as harassment, well, I guess we're going to have to cross that bridge once we get to it. But this was not intended to harass. I made this video at the request of a viewer. And it's everything I've shown tonight, everything I've talked about is public record. There's absolutely, it's all government websites that I've been showing, as well as Lane's YouTube channel, which doesn't mention anybody but Matt Walker. So again, use Lane's website at your own discretion. And with that, I'll see you on the next one. I'm going to click on this and see what happens. Stop the